Good day, everyone. This is Gilbero, and as part of the final output for the course Law-Related Studies, we are assigned to have a mock trial. Thus, today, we are going to analyze JR number 139857, Leonela Batulanon versus People of the Philippines, a case which covers forgery or falsification of documents. Then, this case synopsis goes like this. This petition assails the October 13, 1998 decision of the Court of Appeals in CR number 15221, affirming with modification the April 15, 1993 decision of the Regional Trial Court of General Santos City. Branch 22 in criminal cases numbers 3453, 3625, 3626, and 3627. Convicting Leonela Batulanon of estafa through falsification of commercial documents, and the July 29, 1999 resolution denying the motion for reconsideration. Complainant Palomo Credit Cooperative Incorporated or PCCI employed Batulanon as its cashier or manager from May 1980 up to December 22, 1982. She was in charge of receiving deposits and releasing loans to the member of the cooperative. During an audit conducted, certain irregularities concerning the release of loans were discovered. These are the facts. Petitioner Leonela Batulanon was employed as cashier or manager of Palomo Credit Cooperative Incorporated from 1980 up to December 1982, so that's 2 years. She was in charge with the receiving of deposits and releasing loans to members of the said cooperative. During an audit conducted in December 1982, certain irregularities were found out. Thereafter, for information of estafa through falsification of documents or commercial documents were filed against herein petitioner. So first, criminal case 3625, petitioner Batulanon falsified cash or check voucher of PCCI in the name of Erlinda Umadlaw, making it appear that latter was granted loan where in truth and in fact said person never received, never granted a loan, and never signed such document. Criminal case 3626, same situation as above stated but this time in the name of Gunafreda Oracion. Criminal case 3453, Batulanon falsified commercial documents, namely individual deposits and ledger of Ferlin Arroyo, making it appear that the said person made a fixed deposit and was granted a loan where in truth and in fact, Arroyo never made such deposit and never received such loan. And lastly, criminal case 3627, same situation as the next preceding case but this time in the name of his son, Dennis Batulanon. In all cases, accused did then and there release to herself the same and received the loans and thereafter misappropriated and converted them into her own use and benefit. Also, in all cases, she refused to bring back the same despite demands. These informations were filed in the Regional Trial Court of General Santos City. Petitioner pleaded not guilty. In the ruling of the court on this case, although the offense charged in the information is estafa through falsification of commercial document, appellant could be convicted of falsification of private document. The elements of falsification of private document under Article 172, Paragraph 2 of the Revised Penal Code are first, that the offender committed any acts of falsification except those in Paragraph 7 of Article 171. Second is that the falsification was committed in any private document. And lastly is that the falsification caused damage to a third party or at least the falsification was committed with the intent to cause such damage. So, in criminal cases numbers 3625, 3626, and 3453, Batulanon's act of falsification falls under paragraph 2 of Article 171, causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. So that was the ruling of the court. So however, in criminal case number 3627, the crime committed by Batulanon is estafa and not falsification in criminal case number 3627. Said act does not fall under any of the modes of falsification under Article 171 because therein nothing untruthful about the fact that she used the name of Dennis and that as representative of the latter obtained the proceeds of the loan from PCCI. The essence of falsification is the act of making untruthful or false statements, which is not attendant in this case. Now, so let's talk about the issues. Petitioner brought it up to the Supreme Court and contended that first, best witness is person whose signature is forged. So muna, regarding best witness, Supreme Court cites Section 22 of Rule 132. According to this rule, handwriting may be proved by any person who believes it to be belonging to such person or who acquired knowledge of such handwriting. Thus, she's still liable in forging. So second issue that petitioner raised is that PCCI not prejudiced by loan transactions because loans are accounts receivable by cooperative. Regarding prejudice to Palomo, such loans could have granted to other members but weren't because of illegal acts done by Batulanon. Such constituted damage or prejudice to Palomo, so it could be of benefit to other members of PCCI UNPA. So, now moving forward to the alternatives. In this case, given that they are documents which have been defined as deeds or instruments executed by a private person and without the intervention of a public notary or other person legally authorized, I agree that the Court of Appeals correctly ruled that the subject vouchers are private documents. So in criminal case numbers 3625, 3626, and 3453, I concur that it falls under paragraph 2 of Article 171, causing it to appear that persons have participated in any act or proceeding when they did not in fact so participate. In accordance to the facts presented, petitioner Batulanon falsified cash or check voucher of PCCI in the names of Umadlaw, Oracion, and Arroyo, making it appear that they were granted loan where in truth and in fact, said person never received, never granted a loan, and never signed such document. There is falsification because that what is punished in this act of the offender is causing it to appear that they have received and granted a loan. Furthermore, in these same cases, it could be under paragraph 1 of Article 171, counterfeiting or imitating any handwriting, signature, or rubric. There are two ways of committing falsification under this first act of falsification. First is counterfeiting and B is that feigning. So, mo ni siya. Based on the facts presented, there is feigning. Feigning kay mo ni siya ang there is no original signature, handwriting, or rubric, but a forgery or simulation of a signature, handwriting, or rubric that does not in fact exist. So, in this case, there is feigning for said persons were never granted a loan, never received the same, and never signed the cash or check voucher issued in their names. Batulanon may not attempt to simulate the original signature, but the fact that Umadlaw, Oracion, and Arroyo never signed attest that there shouldn't be such documents in the first place. Moving forward, criminal case 3627 couldn't be considered for falsification of document. However, it could constitute the crime of estafa, as defined and penalized under Article 315, Paragraph 1b of the Revised Penal Code, which states that there be misappropriation or conversion of such money or property by the offender or denial on his part of such receipt. So, she fraudulently used the name of her son, who is likewise disqualified to secure a loan from PCCI. Her misappropriation of the amount she obtained from the loan is also not disputed, as she even admitted receiving the same for personal use. Although the amount received by Batulanon is reflected in the record as part of the receivables of PCCI, damage was still caused to the latter because the sum misappropriated by her could have been loaned by PCCI to qualified members or used in other productive undertakings. At any rate, the disturbance in property rights caused by Batulanon's misappropriation is in itself sufficient to constitute injury within the meaning of Article 315. So, other alternative for this case is that Batulanon have apparent grounds for termination. Ano siya, no? So, Palomo Credit Cooperative Incorporated may terminate petitioner on the following grounds. First, willfully, unlawfully, and feloniously falsified documents of PCCI in the name of Erlinda Umadlaw, Gonofreda Oracion, and Ferlin Arroyo. Then second is that fraudulently used the name of her son, who is likewise disqualified to secure a loan from PCCI. The third and last is that taking advantage of her position and with intent to injustice and swindle the cooperative. So as stated, the manager, cashier of Palomo Credit Cooperative Incorporated, entrusted with the duty of managing the affairs of the cooperative, receiving payments to and collections of the same, and paying out loans to members taking advantage of her position and with intent to prejudice and defraud the cooperative. The grounds aforementioned are enough cause to terminate Batulanon's employment under Article 297A, serious misconduct or willful disobedience, then C, which is fraud or willful breach by the employee of the trust reposed in him by his employer or duly authorized representative. So in conclusion, I concur that the petition lacks merit. Although the offense charged is estafa through falsification of commercial documents, appellant could be convicted of falsification of private documents. Elements of falsification of private documents are present in this case. First, she made it appear that Umadlaw, Ocasio, and Arroyo were granted loans. Second, she made it in private document. So cash, check, vouchers are not public documents because they are not notarized and not documents used by merchants to promote trade nor regulated by Code of Commerce. The third and last is that it caused damage to the cooperative. Therefore, the first, second, and third criminal cases are in fall within the purview of falsification of private documents, but the fourth criminal case with Dennis Batulanon falls within the ambit of the crime of estafa. The latter having no untruthful statements, but there were conversion and misappropriation, hence elements of estafa are present in the last criminal case. That would be all, and thank you everyone for listening. Have a good day.